Good afternoon and welcome to the Public Service Commission of South Carolina. We are here this afternoon for oral arguments on a motion to dismiss and docket number 2023-361-E. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin and Commissioner Caston. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, and Chair Belser. Let me recognize our staff attorney, Ms. Mosier, to read the docket, please.
Thank you, Madam Chair. Good afternoon, commissioners and parties. As noted, we are here today on an oral argument regarding the motion to dismiss that was filed by Dominion Energy South Carolina, Inc. in docket number 2023-361-E, which is the matter of Clyde Kennedy versus Dominion Energy South Carolina. This proceeding has been scheduled for today, February 14th, 2024 at 2 p.m. I believe all parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Ms. Mosier. Let's take appearances of counsel. Who's present for the complainant, Petitioner, Clyde Kennedy? Thank you, Ms. McDaniel. And I'm going to need you to speak into the microphone when you can. And who's present for the defendant, Respondent, Dominion Energy, South Carolina?
Good afternoon, Chair Belser and members of the commission. I'm Chad Burgess. I'm in-house corporate counsel for the company, and with me today is Michael Anselmo from the law firm of McGuire Woods, who serves as our outside counsel. It's a pleasure to appear before you today, and we appreciate this opportunity to present our motion.
Thank you, Mr. Burgess. And the Office of Regulatory Staff.
Thank you, Madam Chair, members of the Commission. Ben Mustian on behalf of ORS.
Thank you, Mr. Mustian. Ladies and gentlemen, our setup here is a little strange since we've got tables for multiple parties from a prior proceeding. I know that we're all used to standing when we address. If you are comfortable seated at your table, you may do so. Just use the microphone. Or you may go to either of the podiums. Just make sure to turn on the microphone. We want everyone to be comfortable here this morning. As this is the motion of Dominion Energy South Carolina, we will hear from Dominion first. Mr. Anselmo.
Thank you, Chair Belser, members of the Commission. Michael Anselmo on behalf of the company. I'm going to put a demonstrative up on the Elmo, and I have copies for counsel and the Commission. Thanks. And again, that's a demonstrative, not intent. I'm not going to admit it, but I think it would help as you follow the argument and as you've gone through the complaint.
And I'm not sure if this is the appropriate moment to do, but I do object to this being used as demonstrative. The only information that's in the record at this point is the complaint and the motion to dismiss, which did not include this. So I think it's inappropriate for the Commission to consider this.
We'll hear a response.
Yes, thank you. In a Green Tree Financial Services case, our Supreme Court has said that if the complaint makes an allegation, such as in the case of the Green Tree case, party breached the contract because of X. The other party, even if the contract isn't attached, is allowed to introduce the contract or refute the direct terms of the motion to dismiss, and it can be considered part and parcel with the motion to dismiss. Again, I'm not seeking this as evidence. It's a convoluted family tree here, so we just thought it would help the Commission get a graphic of what I'm about to tell you orally. But you can utilize documentation and evidence, even for evidence, that is not attached or included in the complaint based on the allegations. Here, Mr. Kennedy has alleged and admitted, in fact, the folks are the relatives that were in the house. So this is merely a graphic representation of the folks in the house.
And Commissioners, I would
There are no
object.
I'm sorry, Ms.
I was just going to say that this is not in the nature of a contract. This is, I don't even know who all the family members are. So this is not something that's just generally known.
I'm going to let you proceed, and we'll take it for what it's worth as we begin our deliberations.
Yep, thanks. All right. Madam Chair, members of the commission, this is a textbook complaint that fits in the application of Rule 103-342K, otherwise known as the K rule. Now that, as you see in our motion, that has some elements, but the complaint admits the very elements of the K rule that trigger its application. Mr. Kennedy himself lived in the house for 7 years, from 2008 to 2015. He admits he owns the house. He allowed his relatives to live there. The relatives admittedly incurred electric charges, and Mr. Kennedy admits the debt is undisputed in the amount of almost $10,000. These admissions are in the complaint and trigger the application of the plain language of the statute. And
Madam Chair, I'm sorry to interrupt, but the allegation that there's something in the complaint about when Mr. Kennedy lived in the property, there's nothing in the complaint about that. That has not been admitted in any case.
Thank you. I'm going to allow him to
thank
continue,
you.
and you'll be able to respond, Ms. McDaniel.
Just for reference, the first line of his complaint says it's his property. The K rule genesis is intended to cover this exact situation. It's a tool that the utilities use to prevent service manipulation, whereby one family member will run up a bill right prior to disconnect. Another family member will apply to the utility to have the service put in their name, and the cycle perpetuates. This is the tool that stops that. The buck has to stop somewhere. This is the property of Mr. Kennedy, and now he's seeking to avoid his obligations and have the power turned on. This has been applied consistently for the last 30 years. And when Mr. Kennedy made his complaint, ORS investigated the matter, and I'm sure Mr. Mustern will confirm that they concluded that DSC did not violate the application of any rule and the K rule. So again, if you look at the K rule, you look at the admissions in the complaint, it's a textbook example. It's like almost like a law school exam question, if you will, of what you need to do to trigger application of the K rule. And we're in a little bit of an awkward position for the utility. Normally when we have an argument, we have filed responses. This matter was stayed for 60 days to allow Mr. Kennedy to find counsel in order to represent him. He, in fact, would more than give us his address so we could serve the answer on him until he had counsel. No return has been filed. So I'm going to assume that what counsel is going to come up and tell you is try to distract and confuse the issue to take this outside the application of K. But the fact of the matter is, and I'll probably address her points on reply, is there's no need to be confused. The plain language of the statute is clear. He owned the property. They ran up a bill. They incurred the debt. The debt is undisputed. This is an uncontested application of a commission reg that's been on the books since the 80s. So this commission should dismiss this complaint as a matter of law on that issue. And then also there is a second allegation of a payment plan allegation. It's very cursory at the bottom, construed most broadly. I guess we need to address it. 2 points there. Mr. Kennedy cannot bring a claim on behalf of a third party. He does not have a payment plan complaint. He brought it on behalf of his relatives. Rule 17 of our Rules of Civil Procedure precede him from bringing a claim. He has not attached any documentation that shows he represents them in any sort of personal representative or fiduciary capacity, so the claim fails. And then also, as the commissioner was aware, 103-352, the trigger is that the payment plan issue has to be prior to disconnect. The complaint itself acknowledges this was a post-disconnect matter because he filed by the allegations of the complaint. So that fails as well. I'm happy to answer any questions at this point, or if you'd prefer me to wait to rebuttal to do so, but it's a very straightforward application of a well-established rule.
Thank you, Mr. Anselmo. Questions at this time? Commissioner Justin Williams, your light is on.
Thank you, Madam Chair. Attorney Anselmo, thank you for being here. And for the argument. Is there a difference between the definition of a household member and a relative based on the K rule?
I don't think you actually have to answer that because unequivocally, these are relatives. It's a very limited situation here where we're asking to apply. We're not seeking a broad rule where you have to make a distinction between a household of unrelated people, which is possible under interpretations of this rule elsewhere. But there is no requirement in the law that sets a set definition of what household is. For instance, I was in my father's household while I attended Wofford College, and he lived in Louisiana because I was a dependent on his tax returns. So the distinct and limited question is, because of this unique factual situation in which this rule is consistently applied here, is their nature of relatives running up a bill with his permission in his property sufficient to trigger the K rule? And the answer to that is it should be yes.
That's all I have, Madam Chair.
Thank you. Commissioners? Okay, thank you, Mr. Anselmo.
Thank you.
Ms. McDaniel?
Thank you, Madam Chair. I'll just present from here if that's
Wherever you're comfortable
Okay.
is fine.
I
Just
think-
make sure you're talking into the microphone. We
Okay.
have some virtual commissioners that need to hear.
certainly. If at any point I fade out, just let me know and I'll be happy to speak up more clearly. I do want to take us back to the complaint so that we have, clearly before you all what actually the complaint says. And it says, Dominion refuses to connect power to my property, no dispute that he owns the house, because the previous tenants, relatives, no dispute that they were relatives, owe them a significant balance. I have evicted the tenants and cannot restore my property without power services. I previously had no payment lapses with the previous utility provider, SCNG. The previous tenants have attempted to establish payment plans with Dominion Energy, and Dominion Energy refuses to accept any payment terms and requires payment in full prior to reconnecting service. Commissioner Williams, I think you hit the nail on the head. What the Dominion is doing with the, quote, K rule is confusing or conflating the definition of relative with the definition of household member. So in the, in the code itself, in the regulations itself, it states that that they can refuse to furnish service or continue service to any applicant who at that time of such application is indebted or any member of his household is indebted. So there's nothing from Dominion saying that Mr. Kennedy previously was indebted. They're hanging their hat on the term member of his household. And it's up to you all to determine what is the definition of member of his household. Mr. Kennedy, as stated in his complaint, lives in California. He does not live in the house in the Low Country where this issue has occurred. And no doubt that the people who lived there were his tenants and were his relatives. But every relative of yours is not a member of your household. If I, lived in a home that my mother owned and she lived down the street, we would not be members of the same household, despite the fact that she owns the house that I live in and she is my mother. Furthermore, it's illogical to think that one person could be a member of more than one household. Mr. Kennedy lives in California with his wife. He is a member of that household. The location here in the Low Country, the people who lived there, that was a separate household. And this interpretation of household member of his household, is supported by not only what we logically know to mean members of a household, which is people who live together, but it's also supported by the definition from Black's Law Dictionary of household, which is, quote, a family living together or a group of people who dwell under the same roof. There is no definition of household in this regulatory scheme, but in the context of automobile insurance, there is a concept of who is a household member. And in the case Buddin, Buddin, v. Nationwide Mutual Insurance Company, which is a Supreme Court case from 1967, 250 SC 332, the South Carolina Supreme Court interpreted resident of the same household as one other than a temporary or transient visitor who lives together with others in the same household for some duration, although he may not intend to remain there permanently. There's nothing in the record that Mr. Kennedy lived in this house with these people, his relatives, for any of the time that is at issue here. So obviously the key definition is living in the same physical house. Again, there's nothing in the regulatory scheme that defines household, and there's really not much case law that defines household. And I'll tell you, when I first contacted opposing counsel to discuss this case, I was like, if there is a policy or a rule or a commission order or a case, let me know, because I do not want to be the person showing up in front of the Public Service Commission looking like an idiot when there's something out there that I should have known. And they all have agreed that there is no case law, there's no commission order on this point. So this is a novel issue for you all to determine. The only case there's the main case that is helpful in this point. I've provided you a copy of it at your desk. It is from the Public Service Commission from 1978. And in that case, a man and a woman were married. The man had a separate business that ran up a large electrical bill. The husband and wife got separated. They were back together. They were separated. They were back together. And whenever they were separated, whenever they were living together, SC&G put the charges for the business property back on her bill. And whenever they moved out from each other, it would not be on her bill. But ultimately, this commission determined that they were members of the same household. What that means, they did in fact live together at the time of that hearing. So they were in the same household. To the extent that there's any other, it would defy logic to think that you could be a son living across, an adult son living across the country and still be living across the country with your wife, with a job, doing your own life, and still be a member of your relative's household simply by owning the property that they live in. So we would ask that the commission determine that the definition of member of his household requires that they, in fact, whoever the member of the household is, they have to live there. They have to live together. And in fact, that is not the case here. And we would, this is a motion to dismiss. By virtue of hearing this level of argument, it almost turns it into more of a dispositive motion, because depending on how you rule, if you determine that the definition of household member requires that they live together in the same house, then there is no further case and our complaint would have to be granted. So that might be a way to move this case forward more quickly. Thank you for listening to me, and I just wanted to say I'm not trying to distract you or confuse you. I'm just trying to get us all on the same page with what people living in the same house means. Thanks.
Ms. McDaniel, I have a question about this case. You're putting forward this case having to do with living in the same household, correct? Because I'm familiar with this case. That case turned on that the utility couldn't just put the prior bill. They were not authorized to move in a bill from one account and put it on another account. Okay.
Yes,
You
ma'am.
agree with me on that, right?
Yes, Madam Chair, I
So
certainly
this
do.
is limited to the household issue.
Yes, Your Honor, that's correct.
Just want to make sure. Thank you. Questions for counsel? Hearing none.
Madam Chair?
Y'all got to be quicker than that. It's been a long morning
It has been a long morning.
for all of us. Commissioner Justin Williams, I think he spoke up first. Then Commissioner Carolee Williams.
Thank you, Madam Chair. Attorney McDaniel, McDaniels or McDaniel?
Just me, one, McDaniel.
Attorney McDaniel, how do you respond to Attorney Anselmo's argument that, but for interpreting the K rule and the way the company interprets it, that a scheme or scam, if you will, of relatives who at one point in time or at the same time lived in the same household could continually run up arrears to the point, if we accept the document that we have here is true, to the point where there is a pretty hefty bill still left to pay. How do you respond to that? That the purpose of the rule in and of itself is to prevent situations like this.
So situations like this, what the K rule was, in my, limited knowledge, is meant to avoid is having people who live in the same house just passing the account amongst themselves. And in this is very different than that. These are tenants, essentially, who live in the house, and we are now trying to charge their electric bill to the landlord. A ruling in this case would not have any effect on Dominion's ability to go after people who did live in the same household, in the same house together for, trying to run that sort of scheme. They would still have the ability to prevent that. I think this is a kind of unusual situation where they're trying to hold a relative responsible when he does not live there.
Thank you, ma'am. Thank you, Madam Chair.
Thank you. Thank you. Commissioner Carolee Williams?
Thank you, Chair Belzer. And Mr. Anselmo, when you began talking, I think I heard you say that Mr. Kennedy had lived in the house from 2008 to 2015. Did I hear that correctly?
You did. That is admittedly outside the bounds of the complaint. But he does admit, if you notice, I previously had no payment lapses with the previous utility provider, which means, one, he lived there, and two, it predated the merger with Dominion, which would have to be logically before 2019.
And was the account in his name in that time frame? And if I ask a question I shouldn't ask, somebody's going to have to tell me.
Let me check the timeline, but that would be outside the scope of the complaint. I think you can look at his own language again without me having to answer with account information. I previously had no payment lapses, which means that he would be on the bill and he had paid it.
So this may also be out of the scope, but Regulation 103-829 and talks about the inability to consider indebtedness which was incurred by the applicant or any member of household more than 6 years prior to the time of application. I'm only raising it because you gave us that time frame. Can you?
I can answer that question as a matter of law. The company is not seeking to recover any sums outside of the limitations imposed by that regulation. Any amount that if we went to a hearing and were at issue would be inside the 6-year window.
Thank you. I appreciate that.
No problem.
May I speak to that point? Okay. So I'm not sure exactly what the total sum of the bill is, but it's in the range of about $10,000. There's nothing in the complaint or there's nothing in evidence that indicates that Mr. Kennedy lived there while that amount of money for the utility was being used while that bill was run up. If he's been gone since 2015, there's obviously that 6-year rule would prevent going back that far. So he would not have even lived there while the service was provided.
Let me see if, what, did you just tell me that he has not lived in the household within the past 6 years?
Correct.
Okay, thank you.
Vice Chair Powers?
Thank you, Madam Chair. Ms. McDaniel, apparently there's a lot we don't know because there's only so much that's in this complaint. We don't know the relationship as far as contractual and, he says tenant and then says relatives. If he had filled out this complaint and not put the word relative, do you think it would make a difference in what we're dealing with today?
That's a good question. I think so, yes. If he had not, disclosed that the people who lived there were his relatives, then they would merely be tenants. And I believe that Dominion somehow knew that they were relatives prior to this complaint being filed, which was why they refused to reconnect the service. So he provided that for, the full facts to be presented.
Are there any relatives in the house or tenants now?
No, he has evicted all of them.
Okay. Who's benefiting from the reconnection service? Is he going to live there? Is he going to rent it out?
Yes, he would be the one. He needs the service to be reconnected because he needs to make repairs to the house. It needs to have heating and cooling. It's sitting without power now for quite some time, which is causing the degradation of the building.
Was a payment plan ever offered to these other people, or do you know?
I have no idea.
Okay. And you don't know whether or not this was rented under a contract or anything?
I do know that information. I mean, it's not before you right now, but there was a lease.
Well,
yes.
Is that going to be filed with us so we'll know more?
If this goes beyond the motion to dismiss, we certainly would file that.
Okay. And there's been no new complaint filed on his behalf or anything else?
No.
Just this one little sheet?
That's correct.
Okay. Well, thank you, ma'am.
Mm-hmm.
Chair Belzer, could I address sorry.
You want to address that? I've been trying to get back to you for your reply, but
We might take care of it in the construct of answering questions, but I'm happy to do whatever's best for y'all.
go ahead, Mr. Anzella.
Commissioner Powers, I think you can still dispose of this matter as a matter of law, even with the unknowns related to the tenant-landlord relative situation. Here's why. The Landlord-Tenant Act has specific formalities, rules, structures, methods of relief that you can find in the code, okay? Those exist independent of the K rule. And what we know from our Supreme Court is that every regulation, statute, rule has to be given to effect under the terms and the intent that the legislature intended. So what the distinction means is you have one set of remedies should you choose to pursue them as a landlord against your tenant. Then you have another set of rules that this commission needs to address, which is the application of K, which must be separate and distinct from that. So the fact, again, as I was talking to Commissioner Williams, the fact that there is the relative relationship is the limited issue we're asking you to address and why it specifically fits into the K rule, because he allowed them to be in the home. He allowed his relatives to incur whatever amount. I mean, the thing on the chart could be $1. It is somewhat immaterial as to the amount for your purposes. That's just for illustrative purposes. But you have to address the K issue, which is wholly separate and distinct from the landlord and tenant situation.
And I understand the landlord-tenant thing. I've been to magistrate court many times as a lawyer and as a magistrate. I've heard those type of cases. It was just so little, and I think that's what you're alleging is it still fails to state facts sufficient to go forward.
I am under the K rule specifically,
Okay.
yes.
Well, thank you.
Sure.
Commissioner Justin Williams, your light's still on. Do you have another question?
Yes, ma'am. This is for both attorneys. I'm working my way through the K rule. Can you all give me or inform me on the business piece of the K rules? The last word in the K rule, business. What business would the K rule apply to?
Commissioner Williams, I think you might be looking at the Smith case okay. So in previous, the K rule was adopted in 1980, I believe. Mm-hmm. In 1994, the commission in one of its rulemaking procedures asked the General Assembly to remove the business language from the K rule. It was in fact removed, I want to say like the March 23rd state register. So that's not an issue at this point inside the K rule. And that speaks to the point that Chair Belzer was talking about, that the Smith case is inapplicable to this matter because it hinged on the business determination rather than what we're have been using the K rule for the 30 years, which is the relative relationship.
So to that point, the fact that we should not take into consideration, and I don't want to put words in your mouth, but I want to sort of get this off the table if it shouldn't be off the table for consideration. If I'm understanding counsel correctly, Attorney McDaniel correctly, the complainant is a landlord who rented this property to what we believe or what has been suggested or relatives. It doesn't matter that he's using this as a business, this account. That's irrelevant to our analysis here today.
I think under the current iteration of the K rule, the fact that it was a business is irrelevant because the rule doesn't allow a business debt to be subsumed within the rule and have this type of roll up. Now, the complaint, we have to accept the allegations is true. He defines tenants as relatives in the parenthetical, so that brings us back within the purview of K. These are his admissions, not anything else.
I'll be happy to hear from you, counsel.
No, I agree. This is not in the nature of a business type of claim for utility services. I will just state that I think it is a bit of a step too far to say that he defines tenants as relatives. He's just pointing out in the complaint that the tenants do happen to be his relatives.
Commissioner, are you through?
Yeah, yes, ma'am. That's all I have.
Okay, thank you. Vice Chair
Madam
Powell?
Chair.
Just
I'm
one-
sorry. Commissioner Caston or Irvin? I'm not sure who I was hearing.
Now, Commissioner Caston.
Commissioner
thank you.
Caston?
Ms. McDaniel, I guess just to clear it up in my mind, relative to the owner of the house living in California, were you saying that the tenants in the property that Dominion is not turning on the service to, since they do not live with the owner of the property who lives in California, or are you saying because he doesn't live at that particular property? I was a little confused on that point.
Okay.
Could you clear that up for me?
Certainly. Yes, I'll be happy to clarify. My point was that he is the owner of the property, but he does not live in the property in South Carolina. He lives in California. So for him to be a member of the household, it's our position that he would have to live in the house receiving the utilities while this bill that is being used to deny reconnection was incurred.
Okay. And I think y'all have already said that this was not in the complaint and beyond the scope as far as whose name or names contracts were in, so I'll just let that go. But I think that's it. Thank you very much.
Mr. Anselmo?
Thank you, Chair Belzer. I was fortunate to be able to address most of the rebuttal
Okay.
points, but I think one thing needs to be addressed, and it's what happens to this amount, whatever it might be, in the event that Mr. Kennedy is not responsible as he should be under K. It does not evaporate into the ether. What happens is it moves into the rate base of the utility for all residential customers to pick up the debt, as is the case with all unrecovered debt. So there is, I think there's a policy reason underlying that treatment of unrecovered debt that underscores what K is supposed to do. And it's supposed to have the utility stop the buck where it needs to stop, rather than having these type of service manipulation games be subsidized by other ratepayers. So,
Mr. Anselmo,
yes.
are you saying that the utility doesn't have a responsibility to pursue other avenues to keep it from being pushed on to other ratepayers?
They absolutely
Okay.
do. And you wouldn't get to this point if those avenues hadn't been already
Well,
exhausted.
Let me ask you this. This is a motion to dismiss. Do we not need to consider this motion in the light most favorable to the non-moving party?
You do.
And I mean, there's a lot that's been brought out here today that indicates that there are factual issues that need to be decided.
Well,
Now, you may dispute that, but I just suppose that.
what our case law on statutory interpretation makes clear is you can't create ambiguity where none actually exists. You can't manufacture controversy, right? And what I think has been pretty consistent from our position is look at the admissions in the complaint, look at the application, well-settled application of the K rule, and that's the end of the inquiry. The company applied the regulation on the book as it should be applied. End of story. The rest of this stuff is not needed to be even included in the decision.
Okay. I'm sorry I interrupted you.
No, but that's not a problem. And also, I've alluded to this about, well, actually, I've addressed all I need to address at this point. I appreciate the commission's time, and if there are any additional questions, I'll answer them, but otherwise, that's all I have.
Anything further, commissioners? I would like to put on the record that this oral argument was scheduled very quickly because I think there are some dates that are pending, and I just wanted to thank the parties, but also put on the record that the parties agreed to the waiver of, I think, 5 days and agreed to be here today. Is that correct, Mr. Anselmo?
That is correct, and that also reminds me that the company would very much appreciate a ruling on this motion tomorrow's business meeting because
That's
we
the
have a
plan.
testament.
That's where I was going from. That's where I was going to next. Ms. McDaniel, is that your you agreed
Yes.
to the quickness of the hearing? And
Absolutely,
And
yes.
Mr. Mustian as well. Is that
Yes.
correct? And that's where I was going to next is it's not the practice to rule from the bench, and we're trying to well, I haven't had a chance to see an amended agenda, but we were trying to put it on tomorrow's agenda at the business meeting so we could make a decision. And that was part of the reason for getting you in here quickly. And I want to give you my thanks and on behalf of the commissioners for indulging us in getting here as quick as you did. So thank you very much.
Thanks to y'all for being here as well.
If there's nothing further with regard to the motion, I've already indicated we'll have it on a commission business meeting and notify you of the decision as soon as possible.
Thank you.
Thank you, and everyone have a good afternoon. And again, thank you for understanding the delay, and have a good afternoon. We're adjourned.